Normally when we draft pleadings and notices, we are informed by the content of the rule itself. The rule specifies, and it's best to use the wording used in the rule because it's specific. But you will look, if you look at the rules of the Magistrates Court, at the back of the rules you have forms which you may refer to assist you to draft a notice requiring security for costs. I hope I've answered your question. Right, today we are going to kick off with Rule 24, which is medical examinations. And the equivalent of Rule 24 will be Rule 36 in the High Court. But Rule 24 is what we use in the Magistrates Court in cases involving damages or compensation in respect of personal injury. And the classic example we have is road accident fund claims or cases of medical negligence or alleged medical negligence. The one party may require the other party to submit themselves to a medical examination by the expert witness of the other party. The party so requesting must in the notice state that the other party is required to present themselves for a medical examination to a specific doctor in a specific location. The address must be provided, a specific date and time must be provided as well. In addition, the party requesting the other party to submit themselves to the medical examination must also in the notice state that they will pay or provide for the expenses to be incurred by the party presenting itself for such medical examination. And that party then, after having subjected themselves to the medical examination in question, must also then request the medical expert to provide a report on that based on the examination that was conducted on that party. And after that examination and the report has been produced, the report must be provided to the other side, the opposition. So that report must be filed within a reasonable period of time after the examination has been conducted. The party that is being requested to avail themselves for the medical examination may also object to being sent to a medical expert, but valid reasons for such objection must be provided by that party. And I have not yet come across a case where a party has refused to subject themselves to a medical examination by a medical expert of the opposing party. Another thing that may happen is that in the notice, this must happen actually, in the notice, the party requiring the other party to go for this medical examination must state that the legal representative of the party going for the medical examination is entitled to be present during the examination. And in my view, it is actually highly recommended that the legal practitioner attends the examination with that party for obvious reasons. There may be intimidation, the party may be subjected to unfair treatment, and there are just so many possibilities of what could go wrong. So I would err on the side of caution and rather attend with my client. You do not want to put your client in the hands of the enemy, so to speak, because after all, these are adversarial proceedings and the parties are in dispute with each other. If the party that has required the other party to go for this medical examination fails to file a report regarding the medical examination after that medical examination, and the period is normally 10 to 15 days. But I think in terms of the filing of the report, the party has 20 days within which to file that report. And if that party has not filed that report, the party that was taken for the medical examination may, through their legal representative, bring an application to compel the other side to file the report. And they may be entitled to costs of that application. In fact, I would even go further by saying that that party may even ask for costs on a punitive scale of attorney and client, because they now have to incur more legal costs by bringing this application, which was totally unnecessary in the circumstances, had it not been for the non-compliance by the other party of not providing the report, despite having sent the one party for an examination with their expert witness. A party may also want to, and I referred to parties here, I did not say the plaintiff or the defendant, deliberately so, because this notice may be sent out by the plaintiff requiring the defendant to go for a medical examination, or vice versa. The defendant may require the plaintiff to avail themselves for a medical examination. Now, in terms of Rule 2410, a party who wants to make use of any plans, diagrams, sketches, models, or photographs at the trial must give the other party notice that they intend to use in evidence those documents. I recall last night someone asked, if you have not discovered documents, how do you use them at trial? The same applies to this case. You cannot make use of any photographs, diagrams, models, or plans without having given your opponent, due notice thereof. And the latest you may do so is 10 days before the trial. You may not do it less than 10 days before trial, but you must also give the other party 10 days within which to provide you with those, within which to object to you using any of those plans, diagrams, models, or photographs. all of the things that we've referred to up to now from when we started with trial preparation for trial. And I'm referring here to the further particulars, although not compulsory, but it's one of the issues to be considered. Discovery of documents, medical examinations and reports, as well as the plans, diagrams, models, and photographs. If in a case for personal injury or bodily injuries, those things have not been attended to, the court will not certify the matter trial ready and will not allocate a date for trial. Nowadays in the high courts, but I know this is also happening in the magistrates' courts lately, a matter is case managed. There's something called case flow management, where the senior magistrate will go through the file. When a party asks for a date of trial to be allocated in a file, the file will be taken by the clerk of the court or the registrar of the regional court to the senior magistrate allocated for civil matters. The magistrate will then go through those files, each one by one, and look at whether the parties have followed proper procedures, whether the parties have filed all the relevant pleadings as well as notices. And if it is found that in a case file, the parties have not complied by not filing all the pleadings, by not filing all the notices, and not having held a pre-trial conference, which I will be dealing with in a moment, then that file may not be allocated a trial date. It may not be allocated a trial date. In the case of a pre-trial conference, a trial date may be allocated, but the parties must have a pre-trial conference before the trial itself. And as I said, a trial date is allocated at least 6 weeks before the date of trial itself. The notice of set down, we said also, the party obtaining the date only needs to give the other party at least 20 days before the date of trial itself. Now, the court will issue. The court is satisfied now that the case file is in order. And I'm now going to deal with 9.5 in your notes. Because our notes differ, because I'm the instructor and you are the students, my notes on 9.5 start on page 129. Rule 26, subpoenas, interrogatories, and commissions de bene esse. Preparing now for trial, the final stages of preparation for trial. All the discovery and the pre-trial notices have been filed and the proceedings have taken place. It is now time for you to ensure that you get your witnesses ready. You prepare for trial, you consult with your witnesses, and you prepare them for trial. Should you have witnesses that you do not wish, that you are not certain will come to court or not, I strongly advise that you issue a subpoena. A subpoena is a document which is issued by the clerk or the registrar of the regional court. Remember, when I say clerk of court, I'm referring to your district court. When I refer to the registrar, your mind should tell you that it's the regional court. So the clerk or the registrar will issue a subpoena, and you will find that in the forms relating to the rules, at the back of the rules, there are forms with regards to subpoenas. Almost every form that you can think of, a notice to discover, you will find in the forms. Almost every notice is catered for in the forms. So you only need to go look there, and there's no need to reinvent the wheel. Even a notice to attend a pretrial conference you will find in the notes. I beg your pardon, in the forms after the rules. The subpoena is basically a document which tells the witness that they must be at court on a specific date, at a specific time, at a specific courtroom. And it will tell them also to stay in attendance until they are no longer required. In other words, you are not going to sit there from 8:30 on Monday, the 6th of March until lunchtime, because you do not know how long the case is going to be. The case might even only start at 2 o'clock, and the witness might only testify on the second or the third day. So it's important that they are told to go to court every single day until they are called, until they have testified, and until they are excused by the court. A subpoena, after you have issued it with the court, will then be served on that witness by the sheriff. Only the sheriff may serve a subpoena on a witness. And the sheriff will also tell that witness, when the sheriff serves that witness with the subpoena, if you fail to come to court, you may be issued with a fine, and or you may be imprisoned for a certain period of time. I think it's 6 months. I just want to check quickly what the punishment is for a witness who fails to come to court. Right, here we are. It's not specified in the rules. But I seem to remember that it was in the region of 600 Rand or 6 months. But I stand corrected. Oh, here we go. It is a fine not exceeding 300 Rands, and in default of payment, imprisonment for a period not exceeding 3 months. So be careful. If you are called as a witness one day, as by way of subpoena, make sure you go to court. But also, if it is your own witness whom you are subpoenaing, explain to your witness beforehand that in terms of the processes of court, I have to subpoena you. I know and I trust you, and I trust that you will come to court. But it will also assist your employer in case your employer requires proof that you went to court. So it's only for those purposes. But please be aware that if you are not coming to court, you may be hit with a fine or imprisonment of up to 3 months. That way too, they will be more convinced to come to court than not. I just want to have a look at section 52 and 53 of the Act, because they also deal with something quite important. Now, section 52 reads as follows. Interrogatories. Whenever a witness resides or is in a district other than that wherein the case is being heard, the court may, if it appears to be consistent with the ends of justice, and upon the application of either party, approve of such interrogatories as either party shall desire to have put to such witness, and shall transmit the same, together with any further interrogatories framed by the court, to the court of the district within which such witness resides or is. So a witness outside of the court, of the district of the court, may be called to come and testify and will be referred to as an interrogatory. In that court which the person resides. And the court shall then, where the person resides, shall then subpoena that witness to appear, and upon his appearance shall take his evidence in manner and form as if he were a witness in a case pending before that court, and shall put to the witness the said interrogatories and such other questions as may be seen to it necessary to obtain full and true answers to the interrogatories, and shall record the evidence of the witness, and shall transmit such record to the court in which such case is pending. So the case where the court where the actual case is will request or permit another court where the witness resides. Let's say for whatever reason, the witness is unable to travel to where the case is being heard. The parties may apply to interrogate that witness in the court in which that witness resides. And then the evidence will be taken and recorded in the same way that it would in any other court. And that evidence would then be transmitted to the court where the case is pending. Right? Now, we also have something which is called Commission's de Bene essay. And the rule 53 says, the court may, in any case which is pending before it, where it may be expedient and consistent with the ends of justice to do so, appoint a person to be a commissioner to take evidence of any witness, whether within the Republic or elsewhere, upon the request of one of the parties to such case after due notice to the other party. If a witness, for whatever reason, is not in the area of jurisdiction of the court, or is even not within the country, and for that reason is not able to come to the court where the case is being heard, the parties may request that a commissioner be appointed, or a commission be appointed where that witness is. And that witness will take the evidence, will record the evidence of that witness where that witness is, and then present it, send it to the court. And the parties, after considering that evidence, may then have that evidence recorded in their case as if the evidence was presented in the court itself. But the trick with that is that witness was not cross-examined. So the court will basically accept the evidence of that witness without having tested the truth thereof. Right, okay. Interesting, it very rarely happens though. I'm yet to come across it. Now, another important aspect of subpoena is duces tecum. Subpoena duces tecum. That's a Latin phrase which means bring the document to court. And this is where, if there is a piece of evidence or documentary evidence which is required in a case, and I'll make an example, a police docket. Police dockets are kept in police custody, and I'm not referring to behind bars now. They have their filing systems, their records department, where all dockets are kept. Mr. DJ Retief, can you please mute your whistling for us? Mr. Retief, can you please mute your mic? Or Miss Retief? Thank you. Can we please just all check that our mics are muted? Thank you. Sipo, Simon Mcb, can you please clarify your question on the dispute? The employer is expected to comply with the subpoena, yes, at all times. No one is above the law and everyone must comply with the law. So that employer who refuses for the employee to be released or to attend court as a witness in a case which involves a dispute with the employer, then it's all the more reason for that employer to want to release the employee to testify in that case, failing which the employer may be held in contempt of court or obstructing the ends of justice. So the police officer who is going to testify in the case is instructed in the subpoena duces tecum. It's normally the station commander, but they never testify. They send the investigating officer to take the docket to court. With the subpoena duces tecum, they will tell the court, I am from police station so-and-so. I was ordered to, in terms of this subpoena duces tecum, to bring the docket. Here is the docket. Court will inspect the docket, and then the party who had subpoenaed the docket will then instruct the police officer as to what to do. Sit in that corner, hold on to that docket until you are called as a witness. And when that witness has testified, the witness is released. But also, if that witness also fails to bring that docket, that subpoena duces tecum, they may also be subjected to a fine or imprisonment for failing to bring the docket to court. Are the police officials not allowed to serve subpoenas? Only in exceptional cases where it is not possible for the sheriff to serve the documents. Can you successfully subpoena documents that are said to be privileged? No, only in exceptional cases. For you to subpoena, to first be entitled to privileged documents, you must show that there's an exception. Only in exceptional cases will privileged documents be permitted to be subpoenaed. But under normal circumstances, no, Mr. Sibanda, you cannot subpoena documents that are privileged. Someone's mic is on. Shirley Ramarupe. Thank you. Right, now we come to pretrial procedure. Pretrial procedure is provided for in Rule 24. Rule 24 tells you the following. Sorry, Rule 25. The purpose of pretrial procedure is to limit the issues in dispute between the parties. Also, to formulate the issues for the court to better understand what the issues are. And in most cases, it even assists the parties to formulate the issues, because some parties will litigate blindly, and only when it comes to the issue, to the stage of pretrial, do the parties realize what the issues actually are. And sadly so, that is the reality of practice out there. So it's one thing that you should guard against. Do your research. If you want to litigate, do your research before you litigate and not afterwards. I know many practitioners who only do their research afterwards, only to be embarrassed to find out that there are no cases in their favor. So be sure you research your cause of action before you institute proceedings, so that you have authorities in your favor, in your client's favor. Then, when it comes to pretrial procedure or the stage of pretrial, it will be simple to formulate the issues. Can a witness be subpoenaed to appear during closing arguments to produce a document or an instrument? When you are, Gilbert, when you are at closing argument stage, evidence has already been led by all parties. So you cannot subpoena a witness at this stage. You have to do so before closing argument. And you may subpoena a witness right up to before closing argument, because then you can still examine that witness. If for whatever reason during proceedings or of testifying by witnesses, it becomes apparent that there is a witness who is vital for the case of either of the parties, that party may at that stage stop the proceedings or request the court that the proceedings be stopped, make an application for the postponement or the standing down of the case in order to subpoena a person as a witness or a document which is critical at that stage. Should it become only should it become available at that stage. But if it was not known, and if it was not known before then, but if it was known before the trial even started that there may be a witness, a specific witness who's necessary and needs to be subpoenaed, the court will not allow that witness to the proceedings to be stopped at a later stage just so the person can be subpoenaed. The court will blindly refuse, point blank refuse, because it shows that you did not prepare your case properly and you are wasting the court's time and you don't know how to conduct your trial. Under normal circumstances, the parties are to hold a pretrial conference between themselves, where they will outline the issues and so on. But the magistrates' courts have found that the parties do not formulate the issues properly. They do not limit the issues properly when they have their pretrial conferences on their own. So the courts desire that parties hold pretrial conferences before a magistrate. The magistrate will preside over a pretrial conference, normally done in the magistrate's chambers. The parties will sit around the table. The plaintiff's attorney will be present, and the defendant's attorney may be present, with the magistrate presiding over the proceedings. They will look at the file. They will then go through a set of questions. And these questions are normally standard questions. And the standard questions which are asked at a pretrial conference are the following. Is there any non-compliance of the rules of court by any of the parties? And if so, does that non-compliance prejudice any party? And if so, how is that party prejudiced? It could be that one of the parties has not discovered in terms of Rule 23, sorry. And because that party has not discovered, the other party may be prejudiced because they do not know which documents are in the possession of the other party. So it may be fair and reasonable for them to object that they will be prejudiced. And because of that, the magistrate may then say to the parties, okay, because there will be prejudice, how much time does the defendant, let's say it's the defendant who has not complied, how much time does the defendant require to comply with Rule 23 and discover? 10 days. And the magistrate will say, all right, fine. We will then draft a minute. And one of the things we will say in that minute will be that the defendant will file his discovery affidavit within 10 days of the parties signing the minutes. Okay? Another issue which may be considered in the pretrial conference is that of settlement. The court will almost every time ask the parties, are you sure there are no prospects of settling this matter between the parties? Magistrates are trained and have insight into the case. When they look at the file, you must remember now, when you are acting on behalf of your client, you have a particular view. You are subjective because this is your client whom you are representing. You do not necessarily agree with what the other party is saying because you have to support your client. And it's easy to become blinded and not to become impartial and to see the issues from a neutral position. It's impossible because you represent a client. Both parties have blinkers on only for their clients. It is therefore the magistrate who is better placed and trained to be able to show the parties that this is the actual dispute. And from where I am sitting as the person who may be deciding on this case, I see things as follows. And magistrates are allowed to give a prima facie view on something. And it is only to guide the parties in the right direction. And the parties do not necessarily have to agree or accept what the magistrate tells them. But good advice should never be frowned upon. And that is the point when you now, as the legal representative for your client, should start thinking critically and objectively about your case. But wait a minute, they are actually correct. The magistrate is also correct. There's actually something missing here. And this is it. That aha moment happens, sometimes very late, sometimes very early, but it doesn't mean that it must not happen. So settlement is always an option which must be considered, especially where the magistrate points it out that it's so glaring that the parties should actually consider it. Where a plaintiff sues a defendant, the defendant has merely denied it, or the defendant has not raised a bona fide defense. So the magistrate points it out to that party. It is up to that party to then consider settlement at that stage. And if the parties during that pretrial conference decide that the defendant wants to settle the plaintiff's claim there and then, the court may make it an order of court. They don't have to wait for a date of trial or the date of trial, and then at court only. Courts are all about settling matters as soon as possible. When it becomes clear that the case can be settled, the court will accommodate them and immediately make that an order of court. Because the court's rolls are unnecessarily clogged with cases which should not have come to court. I'm not saying all cases should not have come to court, but many cases should not go to court at all. So know when your case should not have been in court. Right. Another issue which the court looks at in the pretrial proceedings is whether the case should be transferred to another court. Maybe for reasons such as jurisdiction or so, but that is something looked at. The court may even suggest that, does the matter need to be referred to mediation, arbitration? Those things are also looked at a pretrial conference. Then the court looks at during pretrial conference, just a moment. It's just slipped my mind. I'm reading from the rules, not from the notes. You won't find this in the notes, by the way. Yes, the court will look at who has the duty to begin and who has the onus to prove. If it's a simple claim in convention only, in most cases, it is the plaintiff who has the duty to begin and has the onus to prove their case. But be very careful in cases such as unlawful arrest and detention and assault by police officers. The police, where they have admitted only, have the onus to prove that the arrest, detention, and the shooting, let's say the person was shot by the police, are lawful. So the onus is on you to show it was lawful under the circumstances. That is one of the rare cases in which the onus shifts to the defendant and not the plaintiff. All right, just some useless information there. Nhlakanipho, September, you are taking us way, way back now. We will have to take your question at the end of the session if we have time. Let us deal with relevant issues that we are dealing with now. All right. Should we have time after our session here? We will drive your car back to where we were. All right, with regards to locus standi. Right. Now, you need to look at the rule relating to pretrial procedure, where you will be told what issues you may discuss at a pretrial conference. But the ones I've mentioned to you are some of the important ones. You also need to indicate how many witnesses you need to call and what will each witness testify. How many days will the trial take and who will be representing whom. Sometimes the magistrate wants to know if the parties will be briefing counsel in the matter. Then they know at least what to expect. The magistrate wants his job to be easier as well and not to be made difficult. So the more questions, more issues they can ventilate at that pretrial conference, the easier the case will become, because then you only focus on certain issues. when you've had a pre-trial conference, that pre-trial conference will inform you that this case is only actually about this one simple point. It's broken down now to one simple point, only because the defendant made certain admissions to the plaintiff's claim. So it only will turn on one thing now, which is in dispute, because everything else has been admitted in the plea. So the pre-trial conference is to do the following: to simplify the issues. You must also consider the necessity or the desirability of amendments to the pleadings. So there at your pre-trial conference, you also ask, will any party be amending their pleadings? If so, when will that amendment be done? You don't necessarily have to say what the amendment will be, but give an indication as to how long it will take. Maybe say, all right, within 30 days, the amendment will be effected, because you need to give notice. If there's no objection, then you must perfect your plea or whatever amendment it is you wish to bring. Obtain admissions of fact and of documents from the other side. Then if those documents are admitted and those facts are admitted, you do not need to prove them at the trial. You may also find that because you limit the issues, you may not need to call certain witnesses anymore, because certain evidence which they were going to testify on has now been admitted. Also, the number of expert witnesses may be limited, because if a certain aspect is admitted, you may not need to call that witness at all, that expert witness. And expert witness cost a lot of money. They are expensive. They are very expensive. If you think lawyers are expensive, you should start dealing with expert witnesses. I know there are some pediatricians, one particular neonatologist who's a pediatrician. A neonatologist looks after children with birth defects from the moment they are born until they are discharged from hospital or sent to a special institution. One I know charges 100,000 rands per day. That's in addition to his transport costs and accommodation costs. And do not think you are going to hire a quid from the airport when that expert flies in to testify. He obviously wants a Mercedes-Benz. So you need to know when exactly to use which expert witness and whether you don't need them in a trial. So you must also look at all the other matters which may assist you in the disposal of the action in the most expeditious and important, least costly manner. You cannot call an expert that charges 100,000 rands a day in a case that deals with a debt of 25,000 rand. You're going to have to do the sums. All right? Logic will dictate what procedure you follow and when. Right, now, Rule 27. Rule 27 deals with withdrawals, dismissals, and settlements.
May I please ask a question?
I beg your pardon?
May I ask one question, Advocate, in relation to pre-trial conference?
Yes, sir, you may.
Yes, I just want to check who has to initiate the pre-trial conference, and secondly, if you represent yourself, will I also, will pre-trial conference take place or not?
Okay.
And the last one is to say, the client, is it compulsory that as a client, I should be part of the pre-trial conference or not? Thank you. Okay.
Okay, you've asked 3 questions there.
Yes.
The first question. Let me start with the person representing themselves. A party representing themselves. Remember last night I said, if a party decides to represent themselves, they are stepping into the arena of the court's rules and procedures. And they must make absolutely sure that when they do step in there, they will have to familiarize themselves with and follow the procedures of the court. So yes, if a party represents him or herself, they will have to attend that pre-trial conference as the party. Your last question with regards to whether it's compulsory for a party to be present at a pre-trial conference, my response is a definite no. Pre-trial conferences, and my no means it's not compulsory. I, as a rule, do not allow my clients to be present at pre-trial conferences. Pre-trial conferences deal with technical legal issues which practitioners understand and ventilate between themselves. Clients, you will recall now, are involved emotionally in the case, and it is not yet their time to have their say. It is only when the case goes to court that the client or the witness the party becomes involved, and it's necessary for the party to be there. It may become heated in a pre-trial conference when a party, and it will waste more time because you will have to explain everything to the party, to the plaintiff. Now, what will guide you is before the pre-trial conference itself, you do not just merely go there. There is an agenda that is sent to the other parties so that they know what the issues are that are going to be ventilated at the pre-trial conference. And you, as the representative of the party, will consult with your client before the pre-trial conference so that you can get instructions from your client on each and every point that's to be discussed there. And you will represent your client at the pre-trial conference. If your client insists that they want to attend the pre-trial conference, you must tell them the following. You are allowed to attend, but you're not allowed to open your mouth. Simple as that. It's going to defeat the purpose of a pre-trial conference if you take your client to a pre-trial conference. What was your first question again?
Well, the first question relates to who should initiate the pre-conference.
Right. Any party may initiate the pre-trial process by sending a notice to the other side to request them to attend a pre-trial conference. But where it's going to be held before a magistrate, you contact the clerk or the registrar and ask them for a date when the magistrate will be available to convene a pre-trial conference. Have I answered your questions satisfactorily?
Yes, it did. Thank you very much, Advocate.
Thank you, sir. Right.
A question, Advocate. At the High Court, is a judge presiding over a pre-conference session?
We are dealing with magistrates court practice, sir. Do you want to know if a judge does that in High Court as well? Is that your question?
Yes.
Yes, a judge may, but it's not compulsory.
Okay, thank you.
The parties agreed during the pre-trial conference who will draft the minutes, but it's normally the party who calls for the pre-trial conference who will record the minutes. But it's in the interest of both parties to write down the minutes. And when the one party emails the minutes to the other party for signature, you have your notes with you to check if it is really what has happened. And it's very simple. You print the agenda that's sent to you before, and when you go to the pre-trial conference, you make notes next to each question or topic that is being discussed. And then you decide there and then who's going to do the minutes. Okay, I'll do it. Will you do it? No, it's fine, I'll do it. And then you send it off to the other one. I hope that answers your question, Sipho.
Thanks, Advocate.
Thank you. Okay. Now, before we take our very short break, I want to deal with withdrawals, dismissals, and settlements. A party may withdraw a case at any time of the proceedings by serving a notice of withdrawal on the legal representatives of that party. The notice will tell them it's a notice of withdrawal, the heading with the parties, the case number, and the court. Take notice that the plaintiff hereby withdraws his action in this matter. Very important, the plaintiff hereby tenders the costs of the defendant for the withdrawal of the case. The winner wins. The winner takes it all in law. It's also something called costs follow the cause. So whoever wins the case gets awarded costs against the party that lost. And where a party that withdraws a case does not specify or agree to pay the costs of the winning party, that winning party may go to court to get the court to order the party that withdrew to pay the costs of the party that's won. Cost follows suit. Yes, sir, you are correct, ma'am. You are correct. Cost follows suit. Cost follow the cause. Settlements. We spoke about settlements earlier on. We said that parties settle at any time before the case goes to court. And where the parties settle, they will normally enter into a deed of settlement in which the terms of the settlement are set out meticulously. And when that deed of settlement has been drawn up, the parties will sign it. They will own it. In other words, they will show the court that both of them agreed to the settlement. That settlement is then taken to court and it's made an order of court so that when one of the parties defaults on that settlement, the other party may enforce it because it's now an order of court, either by bringing an application for contempt or obtaining judgment against the defaulting party. And it's important that the settlement agreement between the parties is worded clearly in understandable language, and you must take full instructions from your clients when you settle. Read the settlement agreement to your client over and over and over until they understand. And write that settlement agreement in language that is plain and simple for your client to understand. You are not writing for another lawyer, you are writing for yourself. And that is the mistake that most lawyers make, is that they think they are writing for other lawyers. Even so, they confuse themselves in the process. So keep it simple, keep it plain. What happens in a situation where one party seeks to settle and withdraw the matter, but the other party insists on proceeding with trial? Who will bear the costs of the trial? Okay, now settling and withdrawing the matter are two different things. Let's first clarify that. Where you settle is where there's agreement between the parties. Where you withdraw, there's not necessarily agreement. But either way, I don't see why another party will refuse for a party to withdraw a matter and tender the costs. Even if they don't tender the costs, The mere withdrawal of a matter means they've conceded. Why would you want to go to trial? You may want to go to trial only for purposes of obtaining costs of the withdrawal. Settling, if a party wants to settle, settlement is something that's agreed upon between two parties. It's not a one-sided thing, and you can't force your opponent to settle. If it's on terms less favorable to them, they're not obliged to settle. They're not obliged to settle if it's in terms less favorable to their client. All right, Obakeng, I hope I've answered you there. Dismissals. When a case goes to court and the magistrate's finding is that the case is dismissed, or rather if the defendant applies for dismissal of the action, if the plaintiff does not apply for date of trial, that is possible. The court may look at the circumstances and find that the plaintiff has delayed here in bringing the case to court, and therefore the defendant is entitled to come to court to dismiss the plaintiff's claim. If the court is satisfied that that is indeed the situation and that the plaintiff has not moved his or her feet in the matter, the court may dismiss the plaintiff's claim with costs. Right. We're going to take a short break now for about 10 minutes or 15 minutes, and then we can come back. Now 34, 35. Let's come back at 10 to 7. Then we can kick for touch. Thank you.
Chichi, break.
Right, we are back. If you have been following the program that you were given before we started this week, you will have noticed that we are coming to the end of our program, despite us having lost a few hours on Tuesday evening. Before we start with application proceedings, I want to touch briefly on the trial, which is number 11 on your program. There, we have looked at before the trial. Now, before the trial, if your client, you need to decide who your witnesses are going to be. And by the way, this is not in the notes. This is not in the notes. Okay. Can we keep questions now for when we have finished here? Because it's interrupting the flow of things right now. So when we are done, you may ask your questions. When we are done, I will ask them. I will try to answer your questions at the end if we still have time. But for now, my aim is to try and finish as much as I can of the program. Right now, as I said, you need to decide which witnesses you are going to call. Remember, we are still dealing with action here. You need to decide which witnesses you are going to call, what those witnesses are going to say, and you need to prepare your witness before court. Make your witness understand what it is that they need to tell the court and why you are calling them as a witness. Do not coach your witness what to say word for word. Let your witness testify as naturally as possible. Because if you coach your witness to testify word for word, they will make a mistake. Not may, they will make a mistake. I can guarantee you. Because under cross-examination, they will be asked questions in a different way than you had asked them under examination in chief. And then they will not recall how to answer that question. So as naturally as possible, let them tell the story. Let them understand what evidence it is that they need to introduce and why they need to do that. And then I can guarantee you that your witness will do well in court if they understand why they are testifying, what they need to testify on, and how they need to testify. Not necessarily to lie or mislead the court. You must make that very clear to your witness that they must at all times avoid lying to the court. If they are caught out, it can be embarrassing for both you and that witness. But make sure that you call the relevant witnesses and not just any witness. If you call witnesses and it transpires that that is not a relevant witness, it's going to suggest to the court, to your opponent, and to your client that you do not know what your case is about and how to prove your case. We spoke about, when we talked about pretrial proceedings, we spoke about the duty to begin. And as I said, in most cases, it is the plaintiff. The onus, the duty to begin rests on the plaintiff. And I told you about the exception where in arrest and detention cases and assault cases against the police, those are the exceptions of who has the duty to begin. The plaintiff, when the plaintiff begins, the plaintiff stands up, or the representative for the plaintiff rather, stands up, tells the court they are acting on behalf of the plaintiff, sits down, the defendant's representative stands up and says, I represent the defendant in this case. Sits down and the plaintiff stands up again. The plaintiff then does an opening statement. Forget all the stuff that you saw on Suits and on Netflix in respect of American law. Our law is not as dramatic as that. First of all, we stand still in one spot at the desk you are allocated in court. You do not walk up and down, and we do not have a jury system in South Africa. You address the court in your opening statement by telling the court what your case is about. After you've told the court what your case is about, you tell the court what the facts, the relevant facts are in support of your case. After you've told the court what the relevant facts are, you tell the court what the legal principle or principles involved are in the case. You then tell the court that you are going to prove your client's case in the following manner by calling the following witnesses. And this is what these witnesses will say. And then you tell the court, you will prove this by calling these witnesses, and you will start by calling this witness. Then your witness comes forward. Your first witness comes forward into the witness box. The witness is sworn in. That part where the witness is asked, do you swear that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, so help me God. So help me God. Thank you. You may be seated if it's not going to be a long testimony. Then you start with examination in chief. This is where you now allow your witness to tell their story. He or she must tell the court their story. And it is something to the following effect. When the court swears the witness in, the court will ask the witness for his or her full names. And after that, you will then have to lead that witness in evidence in chief. Sir, Mr. So-and-so, what is your occupation? How old are you? How long have you been working where you are working? On a specific date, or rather, can you tell the court what transpired on the 26th of September 2022? Then you let the witness tell their story. You interject now and then to seek clarity on certain evidence. You may not ask leading questions in examination in chief. You may ask open-ended questions. For instance, if the witness testified, I was moving along York Road. Okay. Can you tell us how you were moving? That's an open-ended question. An example of a leading question would be, were you walking down York Road? Which is wrong. It's a leading question. You may not ask that question. Your opponent will immediately object if they are sharp enough to pick up that it's a leading question. Or the court may tell you, you are asking a leading question. The magistrate will tell you, you are asking a leading question. It is only under cross-examination that you may ask leading questions. And under cross-examination, you will ask questions on the evidence already testified by the witness under examination in chief. You may not venture outside of that evidence. You may only ask questions on that evidence that was given. Mr. So-and-so, in your evidence in chief, you said you were moving down or along York Road. How were you moving down York Road? Were you walking? Were you running? Were you driving a car, a bus, a truck, a motorbike, a bicycle? You may ask a question like that under cross-examination. Under re-examination, and also you may also put versions to the witness under cross-examination. You tell, because it is not your witness that you are cross-examining, and you will still get a chance when you represent the defendant to lead their case, to ask questions. Then you say to that witness, Mr. So-and-so, my client is going to testify here later on, and he is going to say that you were not moving along York Road, but that you were moving along Nelson Mandela Drive. What do you say to that? No, it's not like that. I'm sure it's York Road and not Nelson Mandela Drive. Okay, thank you. Next question. My client is also going to testify here later on that you were not alone when you're moving along Nelson Mandela Drive. You were actually with two other persons who were intoxicated. What do you say to that? No, that is not correct. All right. My client is also going to testify that you were also intoxicated on the day in question, and that is why you are not able to know whether you were in York Road or Nelson Mandela Drive when the incident occurred. What do you say to that? And from those responses, the magistrate will make inferences about the demeanor and the conduct of that witness. If the witness hesitates or is argumentative with the attorney who is cross-examining him, the court may make a negative inference on his evidence and disregard it in total. Which is why at the end of the case, when the parties now, after the plaintiff has called his witnesses and he closes his case when he's finished with his witnesses, tells the court, I'm now closing my case. The defendant then stands up, does not have to do an opening statement, but if necessary, the defendant's opening statement will be along the same lines as the plaintiff's, except the defendant will disclose his cause of action, his defense, and tell the court that this is the law that is applicable, and this is how he intends to prove to show his defense, and he will call these witnesses who are going to say the following in a similar fashion as the plaintiff did when he did his opening statement. At closing argument stage, when both parties have closed their case, the plaintiff will stand up first and do closing argument, referring to evidence by the witnesses, and then telling the court that that evidence, your worship, proves that the plaintiff is entitled to the remedy he's seeking here, and I ask in respect thereof that the court grants the relief sought in the summons and particulars of claim. The defendant will then have an opportunity to do his or her closing argument, where they will also refer the court to evidence and will even ask the court to disregard the evidence of a certain witness because they were not reliable. They were not clear on certain issues. They misled the court. And this is what they said when they misled the court. This is what they said when they were asked a question and they gave the wrong answer. You point out the weaknesses in the evidence of the witnesses, and then you say, you hereby ask the court, therefore, to dismiss the plaintiff's claim with costs as they have not proved their case. When a case, for whatever reason, is not capable of being completed by the parties because of time or because one of the practitioners is not available, a witness is not available, or the magistrate has to go to another court or has an emergency somewhere, the case does not get finished. The case must therefore be stopped. And sometimes there will not be a date available for that case to be heard, but that case will now become part heard or partly heard by the magistrate. The magistrate is therefore seized with the case. It cannot go to another magistrate. It must be heard by this particular magistrate who's already heard evidence on the case. In that case, the parties will postpone the case where there is no date available, sine die. In other words, without a date. That is how they will postpone the case, sine die. And because it is neither party's fault that the matter is postponed, the matter will be, there will not be an order of costs. The magistrate may say costs will be in the course or costs will be reserved. But if it's no party's fault, the magistrate will say costs will be in the course if it's the court's fault. Okay, that then concludes our session. I am now going to, as promised last night, deal with some of the issues which are supposed to be for your self-study. But let's first play some rugby here and see what questions you have. Lion wants to know, what is the difference between the dismissal of an action and a withdrawal? Okay, Lion, what happens is when an action is dismissed, right? It is an order made by the court, right? The court orders that the case be dismissed. It's not. Okay. Okay, may I continue? All right, so the court orders the dismissal of an action after the application by one party for such dismissal. And an application may be verbal. It may also be in writing on notice. But the court orders the dismissal of an action. The withdrawal of an action is done by one of the parties. And an action may only be withdrawn with the leave of the court. A party may not just withdraw the action on their own and expect the matter to be withdrawn. The court must sanction that withdrawal. I hope I've clarified that difference.
Yes, Advocate, you have. Thank you very much.
Okay, now the impact of each of these on a case. Dismissal of the action means that, remember now, the plaintiff institutes the action. So if the action is dismissed, it means the plaintiff loses. It means that the defendant wins. That's the impact. And the other impact is the plaintiff will have to now pay the costs of the defendant, having to instruct attorneys to defend the case. Lorato wants to know, do I need to specify which witness will cover which element of the offense? Not necessarily, Lorato, but if you can, it will be useful to the court. It will also impress your client that you actually know what you are doing. Okay. Utitao, we have the Lions here today. When can we say a witness is hostile? What behavior does a hostile witness possess? All right, a hostile witness is not necessarily a violent person or an aggressive person. It is a person who refuses to cooperate with you, who refuses to consult with you, who refuses to testify on your behalf, who's just a difficult person. What you may make an application to court actually on your feet, while not necessarily in writing. Ask the court to declare someone a hostile witness because they are not cooperative. The court will then order that person to cooperate with the court. But you may make that finding about that witness also before they even come to court, where you've consulted with them and they are just not cooperative at all. Then you may see that this person is a hostile witness and you will have to treat them in a special manner. Okay. I hope I've answered you. Right. Now, you are fortunate. I'm going to go through the list now in terms of applications. You are fortunate in that 2 days ago, on Wednesday evening, I dealt with, actually it was last night, and Wednesday, I touched on certain aspects of some of the self-study topics that are listed here. Execution, for instance, and we are not talking about hanging someone here now, please. Execution means how do you execute an order or a judgment? So I touched on that, but I will briefly touch on some of these aspects now. Application proceedings, we said, are opposed to action proceedings. Now, action proceedings, we know you are anticipating that there is going to be a dispute of fact. That's why you follow the action proceeding. You're also following the action procedures where you are directed by the law to do so. For instance, a claim for damages. You can only institute a claim for damages by way of action. You cannot go by way of application. A divorce, you can only institute a divorce by way of action and not application. Until a good few years ago, divorces could only be instituted in the High Court. But the regional court has now been empowered to also deal with divorces. And a divorce may be dealt with in the regional court in terms of the jurisdictional limits thereof. You look at the value of the joint estate, whether there are minor children involved, and then you make the decision whether to go to the regional court. The regional court, it was also introduced to make it affordable to people, to couples who want to divorce, because the High Court is more expensive to litigate out of the High Court than it is in the regional court. In the High Court, you may need to even brief an advocate to represent you in a divorce in the High Court. Very few attorneys appear in the High Court because they are simply too busy. And it makes sense to brief an advocate who has more time and is a specialist in court cases to handle a divorce for you in the High Court. Now, I said an application, the application procedure is followed where you do not anticipate a dispute of fact, where there's no real dispute of fact. In other words, the court is able to decide the dispute on the papers before it, the affidavits. We don't have pleadings in applications, we have affidavits. And the affidavits are written in the first person on behalf of the parties that are litigating in the application. It is advisable that the applicant deposes to the founding affidavit in respect of his or her case. It's only in exceptional circumstances where the legal representative will depose to an affidavit in an application on behalf of a party. And I'll make an example thereof now. You have main applications, and you are I'm going to give you examples thereof just now. But whilst an application is pending, you may have another application within that application. That is called an interlocutory application. You may even have an application within an action. While there's an action for damages pending, there becomes a need to bring an application to compel the defendant to file a discovery affidavit. That is called an interlocutory application. It is an application brought whilst there are proceedings pending, be they action or application proceedings, but an interlocutory application is within a process that's already underway. That's how you know what an interlocutory application is. Lion, your question was answered 2 days ago. Is it possible for a case to be transferred or deferred from an application proceedings to action proceedings? Who wants to answer that question?
Yes.
Are you answering that question?
Yes.
Please do.
Okay.
If it is seen that some of the elements of the applications will warrant an action, then it can be changed from application to action.
Thank you. Is that correct? And if not, why not?
It is correct.
Advocate.
Yes.
Okay, I also want to attempt to answer the
Please
question.
do.
Yeah, I think my response would be, in terms of application, as it's been said before, it's where there is no dispute of fact. So sometimes it happens that we think that there is no dispute of fact in the beginning, but as we engage on the matter, we realize that there are actually certain elements that need to be ventilated further, and such can be dealt with in terms of viva voce evidence. So in that case, we can move from application to action. Thank you.
Thank you. Okay. What happens is in an application, the parties must prove their case on the affidavits. And if at any time it becomes apparent that there are material disputes of fact on the papers, on the affidavits, the court may refer those aspects of the application to oral evidence. Then, so to speak, the application will become converted to action proceedings, and the rules relating to action proceedings will then have to be invoked. Okay. So you've got the basic gist of it, but it's just the words that you need to use correctly. Okay, so it's not transferred from an application to an action. It's not deferred from an action to an application, to an action. It is converted from an application into an action. But because it started out as an application, the applicant is ordered to pay the costs of that application for following the wrong route. In other words, for not having anticipated the dispute of fact. Pay the cost of the respondent because you wasted their time, because you should have gone action route. And then when the action, it then gets converted to an action, the parties have to discover if there are any other documents outstanding, and then subpoena if necessary, and get all witnesses present to come and testify. Okay, when it comes to contingency fee agreement matters, if the plaintiff attorney won the case, does the costs go to the plaintiff's client or the attorney? Oh, render. That is actually such an out of scope question, but I will attempt to answer it. When it comes to contingency fee agreement matters, if the attorney won the case, does the costs go to the plaintiff's client or the attorney? A contingency fee agreement specifically states that an attorney will be entitled to a certain amount of money, up to a maximum of 25% of the capital sum. And that's it. If any costs are awarded to the party, those costs go to the party because the plaintiff is entitled to the costs in terms of the fee agreement. But it will depend on the agreement. If the agreement states that they're entitled to the 25% as a maximum, plus taxed or agreed costs, then they may be entitled to both. But as a rule, you cannot say that they are only entitled to the contingency, the costs agreed to, but the agreement will inform as to what exactly they are entitled to. The agreement must be clear on that. Okay, Renda, I hope I've answered your question. Pardon?
I've got a follow-up question based on that cost issue.
On the issue of contingency fee agreements.
Yes.
Okay, I'll allow the question, although we've not dealt with it at all.
Sorry.
Yes, you may ask your follow-up question.
Based on what you said, what happens in a case that the settlement amount is not awarded to, but however the costs are only awarded to the party?
The settlement is not awarded, then the contingency fee agreement becomes useless, because remember, the contingency fee is based on a percentage of the capital sum, and if there's no capital sum, there's no contingency. Those attorneys will only be entitled to the costs awarded to them by the court. And if the court said attorney, party and party costs, they're only entitled to party and party costs.
All right, thank you so much.
Thank you. Okay, on the self-study notes, can you also kindly share your notes, especially what you have touched base on, as some of us couldn't log on in time due to the load shedding and other factors affecting the colleagues. Wandile, I don't think I can share my notes with you. These are instructor's notes, and the notes that you have been given are the notes that you are entitled to. I will get permission from Zuki if I can, but I can't share them directly. I will ask Zuki, and if she agrees, I will ask her to send the notes to you. But I think what you've been given is sufficient. But I will, just for purposes of clarity, speak to Zuki about it and find out. She will inform you then if she can give you the notes that I have. Okay, is it normal for a magistrate to insist on hearing the application strictly on papers, although one party indicates that there are issues that need to be ventilated orally? It happened today in court. Yes, it is possible. Because one party says that there's a dispute of fact does not mean that there actually is a dispute of fact. It does not also mean that the magistrate has to agree. Similarly so, Obakeng, with a settlement. If the parties come to court and tell the court that they have agreed to settle the matter in the following manner. If the court is not satisfied that that is the best possible manner in which to settle the matter, in other words, it's not in the interest of both parties, the court is not obliged to accept that offer of settlement from the parties. If the parties also tell the court, we have decided that the applicant will withdraw the application and the respondent has agreed to pay the applicant's costs. The court is not obliged to accept that either. The court might say something like, but if the applicant is withdrawing the application because the applicant feels they don't have a case, why is the respondent agreeing to pay the costs of the withdrawal? The court has a discretion. Right? Okay. Any further questions before I move on?
Advocate.
Yes, sir.
Yeah, I'm also reading Obakeng's question in another light, and I wanted to perhaps engage on his question, if you allow me.
Sure.
Yeah, I think the way I read it, it's as if the magistrate is insisting to follow a certain position, which one party feels may be an unjustified position. And in my view, if that is the case, and maybe there's a decision insofar as that is concerned, and maybe later on the decision goes against the party who feels that the magistrate perhaps did not follow the rules or was unfair or biased in one form or the other, I think that this matter can then be raised with maybe High Court to say even the procedures were not followed through properly. Thank you, Advocate.
Okay. I think the word insists is a bit strong. Magistrates make rulings, and it's not going to help you to be argumentative with the magistrate. If a magistrate tells you, and you have to make a valid case if you want to argue with the presiding officer. If a presiding officer disagrees with you, what must come out of your mouth after that must make a lot of sense to convince them that you are right and they are wrong. And when you are not happy with the result or the outcome or the decision of the magistrate, in that case, you have the right to appeal or even review the decision of the magistrate. Have I answered you?
May I ask a question, Advocate?
Yes, sir.
Advocate, I just want to check one question in relation to the jurisdiction of divorce proceedings. Well, you have indicated that it can only be done either at a regional court or higher court. Now, I just want to check, why is the value of the things that are to be shared amongst the merit, not be considered that if you like, it happens in other, civil matters, that when you go to a regional court, it must be up to 400,000. So why is that not the value of the estate not considered? Thanks. That was my question, Advocate.
All right. I'm just trying to think here.
Advocate.
The monetary value is still considered in divorces. The monetary value is still considered in divorces. That is what I said earlier. Between 200 and 400,000 rands. So it is a factor. Have I answered you?
Yes, thanks, Advocate.
Thank you.
Advocate.
Yes, sir.
I think the regional court, they said they have been given exception as far as those amount of 400. They were given exception for unlimited in divorces.
Okay, where do we find that?
Oh, my locusana is not here with me, but I know about it, that it is, they were given exception only for divorces that they've got unlimited jurisdiction.
Unlimited jurisdiction.
That's correct.
Okay. I may stand corrected. Does anyone know what the position is? Unfortunately, I don't do divorces, and I've never done one in the regional court. Let's see, there's an amendment, Jurisdiction of Regional Courts Amendment Act. Does anyone know? Does anyone work at the regional court who's able to tell us what the position is with regards to divorces? This is completely outside of our scope, of course, but we are trying to find the answers. No one. Okay.
Advocate.
Yes, sir.
Yeah, mine it's not to give them to answer the question directly, but maybe give my insight or understanding on these things. My view would be the reason why the jurisdiction was granted to the regional court was also to allow maybe people whose estate may not be as high as such, and therefore to avoid clogging the high court, you then refer such matters to regional court so that those people whose estates are lower than 400 could deal with their matters at a lower court with less costs. I think for me that would be the rationale, and I would argue that any matter beyond 400,000 should go to the magistrate court, because if we say in cases of divorce, if a matter involves maybe an estate of R1 million, it goes to regional court, then we would be somewhat confusing.
Usurping the powers of the High Court.
Yeah, I think that would be my contribution. Thank you.
All right.
Advocate.
I want us to conclude on this issue now, because I think we are spending too much time on it, and it's not even part of our program. Sorry to interrupt you, but what I want to finally say on the issue is, we all now have homework, including myself, to find out what the real position is, but it's for your own personal knowledge. It's going to assist all of us And who knows, maybe I start doing divorces in the regional court too. Okay.
Okay.
Thank
Okay,
you.
Advocate, after 10 minutes, I'll come back with the page number from our the guide.
The guides.
Yes.
Okay.
After
All right.
10 minutes. Okay.
Pardon?
After 10 minutes.
Okay. Where are you going?
I'm going inside the internet to look it from the guide, because I read it from the guide that we are giving now.
Oh, I see. Thank you. Thank you for that.
Okay.
Okay, so we've looked at the jurisdiction limits for applications in the Magistrates Court. In applications in the Magistrates Court, the same would apply in respect of monetary values, right? So you need to look at the monetary value because you can bring certain claims, monetary values by way of applications, right? So applications are brought in terms of Rule 55. Rule 55 is your GPS when you are bringing an application. You must look at the provisions of Rule 55. It tells you exactly what you must put in an affidavit when you want to bring an application in the Magistrates Court. And Rule 55 will tell you that every application must be brought on a notice of motion, which is supported by an affidavit, which is called the founding affidavit, and as to the facts upon which the applicant relies for relief. And that notice of motion must be addressed to the party or the parties against whom relief is claimed and to the registrar or the clerk of the court. And where it's necessary or proper to give any person notice of the application, the notice must be addressed to and served on that person. In this case, it will be the respondent or respondents. Then we have the amendment of applications. Now, last night or the night before, we said that you may amend in an application anything that you want to change. But just like in an action, you cannot change an admission to a denial. You must bring a special application if you want to change an admission to a denial, because there's case law in the Supreme Court of Appeal where parties have successfully been precluded from changing an admission to a denial. We've dealt with summary judgment as well. It's an application. Now, coming to rescission of judgment, there were quite a number of questions about, well, one question from one person about rescission of judgment. What is rescission of judgment? A rescission of a judgment is when a party against whom a judgment was obtained seeks to set that judgment aside or cancel that judgment. That is referred to as rescission of the judgment. And you must bring that application on notice to the opponent who obtained the judgment against you. Judgment must be brought, the application must be brought within a reasonable period of time. And when you do not bring it within that reasonable period of time, you must include in your application an application for condonation of the late filing of that application for rescission. And just like every other application, it will be on notice of motion, accompanied by a supporting affidavit or a founding affidavit. And the procedure is the same as in all applications. If the party who obtained the judgment against you or the order against you wants to oppose the application, they must file a notice to oppose within 10 days. And within another 10 days, they must file their answering affidavit. And then after that, the applicant has another bite at the cherry with an opportunity to file a replying affidavit to the answering affidavit. So you see the similarity between the action and the application. The summons and particulars of claim are the same as the notice of motion and the founding affidavit. The plea is equivalent to the answering affidavit, and the replication is equivalent to the replying affidavit. There are many similarities, but you must know the differences between the two. Okay. What is an ex parte application? An ex parte application is an application where you do not have a party as a respondent. For example, after you have successfully completed your period of articles and you now want to be admitted as an attorney or legal practitioner, your application will be ex parte. In other words, there will not be a respondent in your application. It will just be in the application of Obakeng Sibanda, the applicant, in the application for his admission as a legal practitioner of the above honorable court. That is an ex parte application. Another ex parte application, an example thereof, is where someone makes an application for the appointment of a curator. There's not necessarily a respondent there, but even if it is a respondent, such as the Road Accident Fund, it will be an ex parte application. Okay, that's ex parte applications. Remember, I said there is a limit to the number of affidavits to be filed in an application. Only 3 and no more than 3. Only in exceptional circumstances will a party be allowed to file a supplementary or an additional affidavit to the 3 that have already been filed. And that party must make out a case on the papers for wanting to file that application, that affidavit. And the normal reason for that is that the party, there are facts that have only become known to the party after the launching of the proceedings. Okay. Then we've dealt with rescission and variation of judgments. We've said what a rescission application is. Where you want to vary a judgment or an order, you may bring an application again, of course, to court by giving notice to your opposition. And in your affidavit, which is in support of your application for such variation, you will set out the grounds for the variation of the order or the judgment. And if the parties are satisfied, in other words, if they agree with you, there's no opposition to the application, the court will then vary its own order or judgment accordingly. I'm going to look at Rule 60 quickly for you. Right now, you have a procedure called non-compliance with the rules, which includes time limits and errors. And if you have failed to comply with the rules or with any request made in pursuance thereof, that shall be ground for the giving of judgment against the party who is in default. An application will be made by that party, served on the other side, notifying them that they are bringing an application because they have not complied with the rules or any part of the rules, to have it dismissed. Remember, we said in the action proceedings, we also dealt with this aspect. Okay. Attachment insecurity of rent, where a tenant has defaulted on its lease, the landlord may bring an application to attach the property of the tenant, which is in the premises or on the premises. There is also a specific summons with a rent interdict which you may issue for proceedings involving lease agreements and rentals. And that summons, once you issue that summons and you serve it upon the defendant, immediately there is an interdict or an attachment on the property within the premises of the plaintiff and of the defendant. And the defendant, the tenant, is not permitted to remove the goods until the finalization of the case. Edictal citation. Edictal citation is where you get a court order to serve proceedings on a party who is outside of the country. Where a party is inside the country and you don't know their whereabouts, I spoke about this on Wednesday evening, you may bring an application for substituted service. In other words, for the relief that you are seeking to be published in an edition of the local newspaper surrounding in the district where the person was last known to be, as well as we also discussed, you may also serve it on their WhatsApp, on their Facebook page, Twitter, Instagram, social media. We have so many options now to serve on persons. When a party has taken a step which is irregular, such as not having signed the summons, the opposing party may bring an application to set aside that proceeding. But before doing so, that party must serve a notice on the other party to say to them, you have wrongfully issued summons here. The summons you served us with was not signed, and that is an irregular step. Party may then correct it by signing the summons and serving a summons that is signed. That removes the irregular step. But if that party does not take any action to remove that irregular step, the other party may go to court on application and founding affidavit to have that pleading set aside or struck out. Then there is no action. Then if they want to come back to court on a new summons, they will have to tender the costs of that summons that was dismissed, struck out and dismissed. That's irregular proceedings. We've touched on provisional sentence proceedings as well. For your own benefit, read further on it as well. A liquid document is explained there. Liquid amounts are explained, as well as how you need to prove your case as a plaintiff in provisional sentence proceedings. It's actually quite nice readings. There are nice judgments there as well. which will give you more insight. Coming to the question on whether a summary judgment is appealable, and the answer was no, correctly so. The refusal of a summary judgment application may be appealed though. All right, take note. If a magistrate refuses an application for summary judgment, the party that brought the application, in other words, the losing party, may appeal that decision to refuse summary judgment, of course, on good cause shown. Right, we've dealt with execution. So after the collections process now from debt to execution, there are 3 phases. The first is to obtain judgment. And once you've obtained judgment against the party, you attach their property. Attach their property is called execution. The sheriff goes, writes up the property, gives them 30 days within which to pay. If within 30 days they've not paid, you send the sheriff back, go and remove now. Sheriff removes the goods, and then the last stage is to sell the goods in a sale in execution to the highest bidder on auction. Warrants. There are 3 types of warrants. One is the warrant of execution, which we've just referred to now. A warrant for ejectment. In other words, eviction. And the last one is a warrant for delivery of goods. That's in the case of repossession of motor vehicles by the bank. You'll find that happening there. And there are it says Form 32, Form 30, and Form 31. Those forms are at the back of your rules. They're at the back of your rules, and and somebody asked earlier on about whether there's a form for security for costs. Yes, there is. There are forms for almost everything that I've told you about here since Monday. Okay. Section 65. Section 65 is debt collection, basically. A debtor is called before court to come and answer to the claim, right? If the debtor is not there, then the plaintiff or the creditor applies for judgment against them. It even goes beyond that, where the creditor asks the court to call that person before court in terms of Section 65 to come and answer to the claim of the creditor. And when they do come to court, the court conducts a financial inquiry into their financial matters. They must bring with them the proof of their income and proof of their expenses. The court will then make a determination based on that as to what is a reasonable amount that the person has to pay. It's almost like a maintenance inquiry. And the court may also even order that a garnishee order be issued against the salary of that person or wages of that person. It's referred to as an emoluments attachment order. That's a garnishee order. All right?
So may I ask a question?
Yes. Yes, you may go ahead. You may ask a question.
Does the garnishee order also apply to companies, juristic persons?
No. Garnishee order is in respect to someone's salary. What scenario do you have in mind? Remember, we're talking debt here now. And Section 65 proceedings. Can you be more practical, please? Why would you want to garnish your company? I'm asking because I want to understand the question.
Can I throw some light on that?
Please do. Are you working for ESCOM?
Well, no. I wish no, thank God I'm not. No, you have contractors, a person that works for a company, a lot of IT guys, work as contractors. They can't have a contracting contracts of employment, whereby they form a company, and it's a personal service company working for an employer, and possibly maybe in this way they are. I'm not sure, because I stand to be contradicted here, but that's the only way I can see that a company can have a garnishing order against it, is if it's a person working, offering IT services to a company, and instead of them having an employment contract, they've got a contract whereby they will be paid for their contracting services. That's the only way I can see it.
Okay, thank you for that.
Okay, I wanted to come in there, advocate, as well. I think the company can be forced into liquidation in cases where, maybe for an example, let me say a company has leased a land on which it's operating its businesses. Then you fall in default with the rental payments for the lease land. Then, as such, the landowner can go and apply to court to force the company into a liquidation instead of being garnished, because the company cannot be garnished but can be liquidated. Thanks.
Thank you.
May I also add something, sir?
Please do.
Would it also not be whereby a person is a sole director of a company, whereby they've entered in an agreement as a director of that company with someone, maybe let's say for erecting earthworks, and then they've been paid, but they've never got to do the work? Would a person not also be entitled to institute proceedings in terms of Section 65 then?
Okay, I think a garnishing order may only be obtained against a natural person, right? Because it is aimed at attaching the income of a person. That's basically the essence of a garnishing order. A garnishing order is what you agree to. An emoluments attachment order is granted whether you agree to it or not. If you want to secure payment from a company, you may attach any funds in their bank account, because remember, garnishing or an emoluments attachment order is an order in lieu of a guaranteed payment of a salary or a wage to a person. A company or an employer which fails to pay over monies in respect of a garnishee or an emoluments attachment order is subject to criminal prosecution. They may either be, the person responsible for it may either be imprisoned, yes, HR, finance, or whoever the person is in salaries. There may be an order for their imprisonment. That is why they so diligently apply and impose those garnishing orders on your salary. It's because they have a legal duty or an obligation to do so. And if they fail, they will be ordered either to go to jail or imprisoned. Okay. Right, page 38 of my notes states, the result was that, amongst other things, a civil regional court has a monetary jurisdictional limit which is set at 400,000 rands for civil matters and unlimited jurisdiction in divorce matters, subject to the Magistrates Courts Act and rules. Petri, you were correct. I think our page numbers are almost similar. Yours is 39, mine is 38. So I may just have an outdated, slightly outdated one than yours. Okay. So Petri is correct, yes. In divorce matters, the jurisdiction is unlimited. There we have clarity on that.
Is Kumbuzo Kumalo who said that?
I beg your pardon?
It was Kumbuzo Kumalo who said that.
Who sent it on the group, on the chat?
Who said the in divorce cases, the jurisdiction of the regional court is unlimited?
Yes, you are correct.
Thank you. Even my colleagues can also go and look at the matrimonial matters and divorce. I think it's paragraph 5.1. It says the jurisdiction of Magistrate Court Amendment Act 31 of 2008 came into operation on August 9, 2010. The Act amends Magistrate Court Act 32 of 1944 so as to confer on a regional court's jurisdiction the same as that of high courts to hear and determine cases relating to divorce and any question arising thereto. I was just picking some sentences that are going into divorce there. Okay.
All right. Thank you very much for that.
You are welcome.
Okay. Okay. My learned friends, this brings us to the conclusion of our session here for the week. I want to take this opportunity to thank you for your time and for your attention. But most of all, I want to wish you well in your journey, in your legal profession. And I pray that you all have long, very long legal careers. Thank you.
Thank you, Advocate. God bless. Thank you, Advocate.
Thank you,
Thanks a lot,
Advocate.
Advocate.
Thank you so much.
Thank you, Advocate.
Thank you, Advocate. Thank you, Advocate. Thank you, Advocate. All the best to you as well. Thank you.
Thank you, Advocate.
Thank you, Advocate.
Thank you, Advocate, for
Thank you, Advocate.
thank you, Advocate, for good lecture.
Good night, guys.